Here are the answers to the 5 most common questions my domestic violence law firm gets from people facing domestic charges in Ontario. The number of Ontarians facing domestic violence charges has risen quite dramatically since the onset of the COVID-19 pandemic. Every week, my law firm receives dozens of calls and emails from men and women on both sides of domestic cases. Defendants want a clear grasp of their rights. The majority of these are hardworking professionals who've never been in trouble with the law before. They want to know what they can expect from the court process and how quickly they can get back to their normal life. Naturally, they're also worried about the costs of hiring a lawyer. Complainants also call my law firm regularly. Most learn about our services after reading our very popular blog article, Understanding the Victim's Role in Domestic Cases. I'll provide a link in the description below. Those complainants who find my law firm this way are mostly married women who are bewildered and feel let down by the criminal justice system. We're going to return to the interests of complainants in a future video, I promise that. But for now, I want to focus on the rights and interests of those people who are actually facing charges across Ontario. And I want to do that by answering some of the most common questions that my law firm gets. Starting with why you were charged in the first place. Domestic violence charges often come as a complete surprise to the very people who are in the center of them. That's because most Ontarians don't know a simple fact. In our province, and in fact across the country, the police are bound by a little-known policy called mandatory charging. Mandatory charging was developed in response to an era when the police largely downplayed or turned a blind eye to domestic abuse. By forcing the police to lay charges, it's also a policy that's designed to relieve victims of having to make the very difficult decision, which they used to have to do, of whether or not to press charges against their abuser, often while the abuser is standing right there with the police. So what does mandatory charging do? Well, in practical terms, it literally requires the police to lay charges anytime a credible allegation of domestic violence is made. It's really that simple. Regardless of how serious the allegation is or what the wishes of the complainant are, mandatory charging means that the police don't have the discretion not to lay charges once they've heard a credible claim of assault or damage to property or threatening behavior or the like. What's more, the allegation doesn't need to be formalized with a signed or a written statement. It could simply be an utterance made at the scene. The charge could be against the wishes of the complainant. I see this all the time. Both parties could be charged if they make a similar complaint against each other. And there's no real need for corroboration in many cases in the form of a witness or documented injuries. So if you're wondering why you've been charged, especially in cases where the complainant or the victim is unsupportive of the charges, it's likely because of the mandatory charging policy. How long is your court case going to take? Ontarians often want to know the answer to this question, especially where the parties want to reconcile. The answer, unfortunately, is that it depends. Clients are often hung up on the first court appearance after retaining my firm, and they believe wrongly that it's the day that will decide what happens to their charge. In actual fact, the first court appearance is just the beginning of what is usually a much longer legal process. With the assistance of an experienced domestic lawyer, I estimate that most minor cases can be completed in as little as 1 to 5 months after the date of the first court appearance. More serious cases, however, often aren't resolvable without going to trial, and that could mean involvement with the legal system for a year or more. In terms of the factors that can impact how quickly a domestic case moves through the court system, there are actually quite a few. The most important of these is definitely the expectations and objectives of the client. This factors their professional standing, their immigration status, the prospect of divorce proceedings and a custody battle, and of course their position in relation to the actual allegations. Put simply, does the client want the best possible outcome, or do they want the fastest outcome? Because even with a great lawyer by your side, you can't often have both. Flowing from this same consideration are a host of other factors that can significantly impact timelines, like how serious are the allegations? How strong is the evidence? How prompt is the Crown making the disclosure? What are the wishes of the complainant? How willing is the client to actually follow the advice of the domestic lawyer? And yes, I hate to say it, but what is the client's budget? At my law firm, we use our initial free consultations to develop something like a snapshot of the case. And based on that snapshot and your expectations as a client, we can usually provide a relatively accurate assessment of timelines for completion. That's because we do these types of cases day in and day out. Where changing bail conditions is also a desired outcome, for example, to allow husband and wife or same-sex partners to resume contact, we can usually provide an estimate and a sense of feasibility for that project too. In fact, I made a whole video on changing domestic violence bail conditions, so you should check that out if you haven't already. By the way, have I mentioned how helpful it would be if you hit the like button and the subscribe button? Doing this simple thing could actually help my law firm to spread the message and share more information with Canadians about these really important topics. Thanks in advance. The third most common question I get is, do I actually need a lawyer? And this really depends on how much you value your time, anxiety levels, and your liberty. And by liberty, I don't just mean jail. Clients facing domestic charges should take stock of two simple facts. The first is that domestic charges are criminal in nature. This means that although jail and a permanent criminal record aren't always outcomes you need to fear, you should talk to a lawyer about that, there's still always a lot on the line. In fact, in addition to the possibility of jail and a permanent criminal record, every domestic case carries the potential for a number of what we call collateral consequences. These can impact everything from future travel plans, your immigration status, family court proceedings, employment or volunteer record checks, your ability to own firearms or get a Nexus card or to speak to certain people or to go to certain places, or whether you have to provide a sample of your DNA for permanent storage by the government. Oftentimes, these collateral consequences are just as serious, if not more so, than the old-fashioned fear of jail. The second thing you should keep in mind if you're facing domestic charges is that domestic charges are complicated. There's a reason why the best criminal lawyers are tough and persuasive and smart. That's because this is hard and complicated work, and to do it well requires a lot of skill in a lot of different areas. Around every corner of every domestic case is a series of pitfalls that takes experience to navigate. And even once we've navigated these pitfalls, we defense lawyers have some really smart opponents to work around, from judges to crown attorneys to police, which is to say nothing about the complexities of the law itself. Clients who think that they can go it alone are a lot like people who think they can do their own plumbing and electric after a big flood, or suture their own wound after they've cut themselves. Is it doable? Yeah, but will it get messy? Almost certainly. In my view, hiring a skilled domestic violence lawyer is probably the single most important decision you can make after you're facing charges. A good lawyer is not only going to speed up the process and relieve a ton of stress, they're also going to substantially increase your odds of getting the best possible result. On that point, my law firm prides itself on its fair, flexible billing practices. Because of our track record defending so many domestic cases, we're normally able to assess the time requirements of a case after a brief, free initial consultation. This allows us to offer our clients what we call a block fee, meaning you pay a fixed price for legal services you need, and you don't end up paying for the things that you don't. More importantly, it means that there aren't any surprises in your billing. No nightmare bills, no $100 phone calls, no hidden fees. And of course, payment plans are always an option. So you should feel free to call us today if you have a case that you want to discuss. I'd be happy to hear from you. Number 4 is in some ways the most complicated question because it has no real answer. And that is, how do I get my domestic charges dropped? Getting domestic charges dropped is obviously top of mind for the people facing them. This is especially true for the individuals who have never dealt with the system before, and doubly so where the complainant or the victim isn't supportive of the case. Unfortunately, there's no script for getting domestic charges dropped. If there were, I wouldn't be a defense lawyer, I would be a magician. Domestic charges don't spring from nowhere. They almost always emerge from the deep and messy soil of a romantic relationship that is riddled with old problems. When those problems interact with the criminal justice system, the solution isn't going to be quick. It's going to be a process built on equal parts acumen and advocacy. As an aside, this is why I never give guarantees during an initial consultation. I view guarantees as a cheap trick, and I encourage you to think twice and maybe take a step back if you get one in the course of looking for a lawyer. Given how complex each domestic case can be, lawyers like me simply don't have enough information to predict the future when we first talk to a client. We don't have the complainant's input in any reliable way, or the statement that's been given to the police, or an understanding of all the collateral consequences you may be facing and what your priorities are, or quite simply, we don't have a full knowledge of the case. So what can you do to get your domestic charges dropped? I'm here to tell you there is no prescription. And yes, that also includes getting an affidavit, which is probably the single most misunderstood concept clients talk to me about on the regular. I promise to make a video about that separately. Having said all of that, there are 2 golden rules you can follow. And if you do, I would say that you're already off to a very good start towards getting the best result. The first, as you can probably predict, is hire the best lawyer that you can. We've already talked about this in great detail. The second, as I've set out in one of my previous videos, is follow your bail, not your heart. It's easiest to defend against a domestic charge when you're out of custody. The 5th and final question that I get most often from new clients facing domestic charges relates to the first court appearance. The anxiety of a looming court date is understandable, especially for people who've never been in trouble with the law before. But as I've explained in the past, both on this channel and in my blog, your first court appearance isn't a trial. There really isn't that much to worry about. You shouldn't expect there to be any witnesses present or for anybody to ask you your side of the story. That's really not the purpose or the function of a first court appearance. The main purpose of a first court appearance isn't to determine guilt or innocence at all, in fact. Instead, it's the beginning of what is usually a fairly long administrative phase in your case. And you're going to have multiple court appearances like your first court appearance while your case winds its way towards a conclusion. If you want more information on what to expect at a first court appearance, you should check out one of our very first videos on the topic. Although, mind you, COVID-19 has largely changed some of the ways that first court appearances work. How about whether or not you should hire a lawyer before the first court appearance or simply wait for the first court appearance to come and go? In terms of whether or not you should hire a lawyer before the first court appearance, my standard answer is always the same. The sooner you hire the lawyer, the better. I know that sounds self-serving, but think about it. You're almost invariably going to end up hiring a lawyer at some point. So why not make use of the days, weeks, and sometimes even the months leading up to your first court appearance, getting a lawyer to work with you by your side? This will not only significantly reduce your stress by granting you access to a smart professional who can answer your questions, it's also going to give you and your lawyer time and a chance to begin implementing a strategy early that can actually shorten the lifespan of the criminal case against you. In other words, it can speed things up. My law firm usually takes care of the court appearances for you, so you won't even need to go to your first court appearance unless you absolutely want to. There are other benefits to hiring a criminal lawyer before the first court appearance too. Some of these are really important. For example, we can identify and help to secure evidence that you might otherwise discard or overlook. We can recommend appropriate counseling or referrals to other lawyers if you have questions about the family law context, the immigration law context, or employment-related questions. We can speed up the process of getting disclosure because the Crown often won't disclose everything directly to a self-represented litigant. And in some cases, especially where we're talking about spouses, we can help to facilitate an early bail variation. Wrapping everything up, domestic violence charges take a heavy emotional toll on the parties that are involved in them. The combination of emotional pain, uncertainty about the future, and fear of an unknown legal system understandably produces a lot of questions. I want you to rest assured that you're not alone. This list of the top 5 most frequently asked questions and answers is just a sampling of the types of worries that my law firm hears and responds to each and every week, multiple times per week. I sincerely hope that it's been helpful for you, and more importantly, I hope that it's left you feeling a little bit clearer and more empowered. As always, if you have questions about a criminal case, please pick up the phone and give my law firm a call. We'd love to hear from you.